again, Attorney Steve Vondren, civil litigation attorney in arbitration. Don't forget the arbitration, that pops in there too. So we are talking, thank you for joining us. We are back and we are talking in this video about the motion to strike. Motion to strike. So if you're in litigation, in state court or even federal court, doesn't matter. The motion to strike is usually something you see as a plaintiff after you, it doesn't have to be the plaintiff, there's other the defendant's usually filing the motion to strike, but it could be the plaintiff. So there are different opportunities where both parties have the ability to file a motion to strike. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, so we're going to be talking in this video about the motion to strike. As you can see right here, motion to strike. Okay, so what usually happens, this is your common scenario how these things play out. So you file your complaint in state or federal court, you serve the defendant's going to get the papers and go, oh my God, what's going on? It's a lawsuit. They're normally in California state court, they're going to have 30 days to respond. This is 20 days, Arizona state court, FYI. A little something for your cocktail parties there. So 30 days, this is your time to respond. When I say time to respond, you can respond by filing an answer. The defendant sometimes will just answer the complaint. They know you got something good on them. They're just going to answer. Or they may try to be difficult and file a demur. We've done videos on a demur, so if you're not sure what that is, type in demur, Attorney Steve, you'll probably find my video. So the time to respond, 30 days, you can file an answer that's not listed on my chart here. You can file a demur, which basically objects to the forms of the pleading and the causes of action. And you can file a motion to strike, any one or the other. So you have options when you're a defendant representing a party. So now, so we're not going to talk about the demur, that's out of here. We filed a complaint, we talked about service, we're going to be done with that. What we are talking about today in this video though is a couple California rules of court you don't want to get tripped up on, okay? I just tripped an attorney up on these. It was a lot of fun, let me tell you. So I want to share these with you so that you have these in your litigation toolbox. So you have this motion to strike, and I'm going to tell you briefly what the motion to strike is, okay? Motion to strike is basically when there's something in the pleading that's false, irrelevant, scandalous, immoral, false, superfluous. If you have something in your complaint that shouldn't be there, okay? So if you're claiming, you're saying scandalous things about somebody, you can let your mind wander on this, right? Or if you have a cause of action that gets overruled on demur, there's a mechanism to file a motion to strike, okay? The motion to strike seeks to take out these things, okay? Seems to eliminate them from the complaint, okay? So that they're no longer in there in your complaint, okay? So, but the question really, the big question is, let me give you an example. So I filed a lawsuit. In my lawsuit, it was a right of publicity case, okay? And in my case, we talked about a intentional infliction of emotional distress, which we thought was a valid claim. The other party filed a demur within the 30 days, and the court agreed with the defendant that there was no extreme and outrageous conduct. So the demur was sustained as to that cause of action, meaning the defendant won on that point, okay? So it was sustained. So what the other party tried to do was to come forward and later seek to strike, motion to strike, to get that cause of action out of there, to get some of our allegations out there that we thought related to the extreme and outrageous conduct. So they fought hard to get all that out of there. We, of course, wanted to keep it in because we believed that it was relevant to our right of publicity claim and to our right to seek punitive damages, okay? Our right to seek punitive damages. So this was the battleground, was the motion to strike, to get those punitive damages out of there. And we were fighting, as you see. I'm not sure if I had these gloves on or not, but we had the gloves ready if needed. But at any rate, so the motion to strike has to be filed within the right time. Under California rule of court, don't forget these sometimes. If you're a new lawyer, sometimes you forget the California rules of court. Don't do that. They're valuable. Get the book, have it handy, have it ready. We cited the timing elements. We challenged the timing of the filing. as being too late. Okay, I'm not going to go into the details. You probably fall asleep on me. But California Rule of Court 3.1322, usually if you're filing a demur and a motion to strike at the same time, they need to be heard at the same time. Okay, there's your general rule. Now let's go to also the important rule, because this is what happens, trips people up. You get involved in litigation, lots of things going on, and so let's say you get here on a demur and the judge says, you're right, you have no intentional infliction of emotional distress, but you have the right to amend. If you've been practicing law, you'll know the right to amend is usually freely granted to give you a chance to re-allege. Maybe you missed something out. Gives you a chance to come back in and put something in your complaint. Now, you don't have to amend. That's not some, if you can't, if you're squeezing a ball into a square hole, it's not going to fit. So sometimes you don't want to amend. But what happens here is the important rule, California Rule of Court 3.1320, say it with me, California Rule of Court 3.1320, J as in Jackrabbit. You have 10 days following this hearing on the demur. This is the triggering point. Okay, there's a lot of law and motion practice. You have the demur, the judge sustains the demur without leave to amend. California Rule of Court kicks in, 3.1320, J says you got 10 days to answer or otherwise plead to the complaint or the other causes of action that are remaining in the complaint. So you have 10 days. There's your timing rule, in case you missed that. 10 days following the sustaining of a demur, or 10 days following a demur being overruled, or 10 days when the judge says you have leave to amend, but the plaintiff says, I'm not going to amend. I don't have the facts right now. I may get them later. I don't know, but I don't have them right now. So if that 10 days expire and the other party's not getting in there filing that motion to strike, you challenge as an untimely, you knock that thing out, and in our case, the punitive damages will stick for this stage of the litigation, which is very important. We want those punitive damages in there. They belong in there. They're inherent in the California Right of Publicity statute, so we want them in there. We don't think they should be struck out. But this is how these things can play out, and if you win on the motion to strike, you keep your punitives in. They don't even get to argue the merits of the punitive damages and try to get the judge to kick it out at this early stage of the litigation. So that's the motion to strike. As you know, if you amend the complaint, if you actually do go through that process, the judge gives you the chance to amend. You have 30 days to answer, demur, file your motion to strike, whatever. If you don't, potential default, CCP 471.5. Check that out if you're involved in that. But hopefully this has been helpful. The motion to strike is a powerful tool if used properly. There's lots of little rules on this, so you may want to go look this up. You can find out more information on our website, VondrenLegal.com. Make it easy. AskAttorneySteve.com will also get you there. And we hope this has been helpful for you. If you like our videos, we appreciate your support. Click the V, send it to your friends. Say, this guy's really cool, keeping me in the know. Okay? Attorney Steve, litigation attorney. Hope you enjoyed this video. We look forward to working with you.